All right, I think we're ready to get started, right? So I'd like to thank you all for taking some time to attend this webinar. My name is Joe Schmitz. I'm the in-house attorney for Uniwile, and we're super excited to partner with Legal Karma to offer estate planning products. The estate planning process, it's super important to be proactive about it. A lot of times we see what happens when there isn't a good plan in place, and it causes a lot of problems and extra confusion. And having a plan in place and being proactive, it just makes things so much easier. So I'm super excited to see that there's so many people here today. We think the products that we can offer with Legal Karma, they're a super good value for our members, and we're just very excited that we have this opportunity to present this to you. So without further ado, I want to hand this over to Meg, the host for the meeting today.
Thank you, Joe. Really excited to be here. My name is Meg Palazzolo. I am an estate planning expert here at Legal Karma. I don't have a legal background, but I've been in this estate planning world for about 7 years, so I know enough to be dangerous in a very good way. I'm here with my colleague and friend Juana. Juana, if you want to say hi to everybody.
Hi, everyone.
Juana will be here to answer any of your questions in the Q&A box throughout this presentation. So there is a Q&A box down at the bottom of your Zoom bar. Go ahead and find that and drop your questions here. We're also going to save a few minutes towards the end for any live questions. So if we get a ton of questions coming in, I'll be answering those live for you all. Some other little housekeeping items, definitely stay until the very end of this presentation. We will be offering a discount that you can all use on an estate plan, so take advantage of that. And then there's also going to be a very brief 1 minute survey. We would love if y'all stayed on till for that as well. Your feedback and insights continue to help us improve these future webinars for other members. And then finally, we will be offering the opportunity to book a call with our estate planning specialist team over here at Legal Karma. So our team, we can't provide legal advice, but we do know a ton about estate planning. We can provide you education to really empower you to make the best decision for you and your family. So, I encourage you all to book a call if your questions aren't answered through this presentation. We will be going into a very high level discussion and overview of estate planning. But there may be some additional questions that come up that would be best to just sit down and speak with somebody from the team. And finally, everything that you hear today should not be considered as legal advice. Okay, so let's dig into the agenda today. We're going to first talk about why estate planning matters. We're going to talk about what it is, the different types of documents that are offered, and then finally, how to get started. We like to kick things off by setting some intentions. Why are we all here? Why are we all thinking about estate planning? It really comes back to the answers or how you answer these three questions. The first is, who are the most important people in your life? It could be family members, it could be friends. For me, it is my husband and our 3-year-old son, whose name is Grayson. The second question is what are the things that matter most in your life that you're wanting to protect? So, could be heirlooms is a common one, things that are passed on from generation to generation. It could be your financial security. That is my reason, financial security, and making sure that when I'm no longer here, everything is passed on to the people that I want. Could be your home. And then finally, what does legacy mean to you? At Legal Karma, it's really about passing on our values and ensuring that our life's accomplishments and dreams continue to inspire those future generations ahead of us. So, however you answered these questions, please hold on to those answers throughout the presentation because we will come back to them. We'll revisit them. I'm just going to pull up the Q&A box too so I can see those coming through. Okay, so the natural first question that most people have is, well, what even is an estate plan? And an estate plan really consists of being able to specify your healthcare wishes, your financial wishes, so legacy or incapacity planning, and then also legacy planning. So the incapacity planning is all about planning for in the event that you're not able to make healthcare or financial decisions. So you're still alive, but maybe perhaps you had an upcoming surgery and you can't make those healthcare decisions or financial decisions. So you're appointing an individual or multiple people to act on your behalf. And the healthcare directive also allows you to specify any healthcare wishes. So I know some religions prohibit blood transfusion, so that would be something to specify in your healthcare directive, or perhaps you would like alternative medicine versus Western medicine. That would be something that you could specify in here as well. And then the power of attorney financial is more around financial decisions. It's in the name, but the things that somebody would have the abilities to do is pay your bills, open up accounts, close accounts, perhaps pay your taxes, perhaps even make investments on your behalf. So it really depends, but you can get specific in these two documents around what types of things you'd want these individuals to do. These should be trusted individuals that you appoint, especially for both of them, but definitely trusted individuals. And then the last documents here, the last will or the revocable living trust. Again, these are all for legacy planning. We'll talk about the details here in a minute, but really deciding who is getting what after you're no longer here. So the natural next question is, well, what even is a will? And a will is a very simple document. It allows you to say what happens to your assets after you pass away. You're also specifying guardians for any minor children, or pets, caretakers for pets. You're appointing an executor. So this person is responsible for carrying out your will through probate. So probate is a state judicial process. It derives from a probate or a Latin word that means to prove. So it's proving that your will is a legitimate will. And your will is taken through probate. So the state is proving that my will is legitimate or was legitimate and that I actually signed it. And then they're releasing my assets over to the executor that I've appointed. So probate can be slow, difficult, and expensive. I actually did probate at my last company, and it was wild, to say the least. So 6 to 12 months is a pretty typical range for probate. I've seen it shorter, but that's a little bit less common. And then it can be difficult. So it's a lengthy process, and there's a lot of paperwork involved. Sometimes you can miss deadlines and you can have to restart the process all over. And then it's often expensive. So ten to $20,000 is pretty typical. So the state will take fees out of probate or from probate during that probate process. And then there's oftentimes attorney fees as well. So it can be costly. A will is also a public document through the probate process. So after probate, your will does become a public document in the county recorders. Um, and you can actually look up deceased individuals' wills if you really wanted to, but it does become a public document. So most people do look to avoid the probate process, or some people look to avoid the probate process, I should say. And that's where a trust comes in. So a trust is a set of documents. So a trust comes with a will, a little confusing. A will is a standalone document, last will is a standalone document, but a trust works with a will. A pour over will. I saw that question just pop up in the chat, but a trust is a set of documents that basically say more comprehensive in the sense that allows you to say when and how your assets are distributed. So you are appointing a CEO or a CEO, a successor trustee who think of them as a CEO is the analogy I give, and they are managing all of your assets after you are no longer here. So again, a trust does provide more control over who gets what, when, and how. So I have a younger son. I don't know how financially responsible he is going to be, and perhaps something happens to me before I can see how financially responsible he is. Um, a will may say that my son receives all of the assets, but maybe he's too young to receive that such a big inheritance. And really, a trust will hold on to those assets until he's a specific age, but still make the funds available to him. So the successor trustee could support my son to pay for some of his tuition if he chooses to go to college, or perhaps he wants to purchase a home. The successor trustee could take some of the funds out of the trust to support the down payment on a home. So um, there's a lot of benefits of a trust. We'll go into the different or some of more benefits here shortly, but can really help with younger children and if you're unsure of how financially responsible they'll become. A trust does become or is a private document, so it does not go through probate because throughout one's lifetime, you're retitling or moving assets into the name of the trust. So think of a cookie jar. A cookie jar is just a jar unless you actually put cookies in it. And that's kind of similar with a trust, not as delicious. But instead of saying my name on my deed of my home, I would change to say the name of my trust on the deed, file that new deed with the county recorder's office, and now that home is a part of the trust since it's retitled and follows any of the rules that I've specified. So again, trust funding or moving assets into the name of the trust, it's not a complicated process. We do have a helpful guide that walks you through that, and it can happen throughout your lifetime. And then finally, a trust is active once you sign it. So it can support incapacity planning as well. Some side-by-side differences between a will and a trust. Again, will is a very simple document. You're appointing an executor. You're naming guardians in your will for minor children or adult children with special needs or pet caretakers. You're deciding who is getting what, and it is only effective after passing. A trust gives more control over who is getting what, when, and how, so more flexibility. It's avoiding probate because you're moving assets into the name of the trust. And then it is also a private document and again is effective throughout one's lifetime. It's also technically easier and far less expensive than the end result or the outcome of a will. So, sure, the upfront price might be a little bit more than a will, but we talked about the fees associated with probate. So, with a trust, you're essentially avoiding those fees. So, in theory, the outcome is um, less expensive. Can be less expensive, I should say. Reasons to add a trust. So it's not really a question of a will versus a trust. They do work together as part of an estate plan. And all estate plans should have a will, but not all estate plans need a trust. So really, you make the decision of what's best for you and your family. But let's talk about some of the reasons you might want to add a trust. We did talk about if there are younger children involved. I gave my example. I don't know how my son will be financially responsible, but this just allows us to have more control over the assets and the distributions. We've appointed a successor trustee, aka my sister, who is financially responsible and would be able to support my son through the trust and managing his assets. If there's any complex family dynamics, so if there's blended families or second marriages that might want, or that you might want to consider adding a trust instead of a will. If you're looking to avoid probate, or if you want your documents to remain private even after you pass away, those are definitely some reasons to add a trust. And then finally, the incapacity planning. So, I hope that provides a little bit of insight around if you're trying to choose between one plan or another. We do have a really helpful quiz when you get started. Um, Before you select a plan, you can fill out this 1 minute quiz and it can help you. It will recommend a plan based on how you answered everything. So, um, you can always change that too. So if it's recommended the will, you can always change it to the trust. So that's also very helpful. Okay. So there's a lot of misconceptions that come up when people think or hear about estate planning and they'll brush off like, oh, I don't need an estate plan, right? So the first one is that it's for the ultra wealthy, and estate planning is not for the ultra wealthy. Estate planning is really for anybody over the age of 18. I say 18 specifically because that's when we become an adult, right? And so a lot of times, young adults, college students going off to college for the first time, mom and dad no longer have the legal authority to make those medical or financial decisions for their young adult now. So putting a power of attorney plan documents in place can definitely help the whole family there. The second one here is that my family already knows what I want. And without documents, it's actually far more complicated going through the probate process than having a document in place. So, a lot of times without documents, there's confusion, there's even more delays. There can be court battles. I mentioned that we did probate at the last company I worked with, and we saw a lot of family conflict from folks that didn't have a plan in place, and it was truly heartbreaking to see families go through that on top of the grieving process that they're already going through. So, really encourage you all to set time aside and put a plan in place, if not for yourselves, but really just for your loved ones, so they can go through that grieving process and more smoothly go through settling your estate. The third one here is that it's too complicated and expensive. The traditional route of going to an attorney is definitely a great option and can serve some folks as well. But it can be complicated. First of all, you're having to find an attorney that shop around. So, where do you go? Do you ask your friends? Do you read Google reviews or Yelp reviews? So, trying to find an attorney to work with you, and then it can be very costly. So, um, I've worked with attorneys that charge anywhere from $3,500 to $15,000 for a trust, and $15,000 is less common, but it can get very costly depending on the specifics you're wanting to add. And a lot of people have very straightforward estates that they're or wishes that they're wanting to put in place, and that's where the the service that we offer here at Legal Karma can really come in. So you're not having to leave your house to go speak to an attorney. It's accessible. You can do it from your home, and it's a fraction of the cost of what an attorney would charge. And then finally, this is the most common reason people will put off creating an estate plan is I can always do it later. How many of us have said that, right? And unfortunately, the only true thing that we know to happen throughout our lifetime is that one day we will no longer be here. We just don't know when that is going to be. So, really, just making this a priority and getting it done. It is part of being an adult. Um, the whole process can take about 40 minutes max if you already have the answers to the questions that come up, but it is a relatively short process. And again, you can do it from your home. Oops. So some of the benefits of having an estate plan, we kind of answered these, but just to reiterate them again, it does remove any of the guesswork for your family members, for your loved ones. You're nominating guardians for your kids, caretakers for your pets. We think of our pets as our children too sometimes. You're empowering trusted individuals to act on your behalf for your health and finances and your legacy planning. You're protecting your assets. You could be avoiding probate. And then again, you're really truly leaving a legacy as you intended. So, kind of going back to how we answered those questions in the very beginning, with having a plan in place, it really does provide that additional peace of mind. Okay, so, well, another common question here is if I have a plan, do I need to update it? So, we talked about the trust that we offer, and the most common trust is called a revocable trust. What that means is you can revoke it or make changes to it throughout your lifetime. So, an estate plan is not made to be a one and done solution. It is made to be updated throughout your lifetime. And usually, some common reasons to update or even create one is around any major life event. So, most people will want to create or think about their mortality around a major life event, but then we'll create an estate plan around a life event or even update it. So, getting married or even divorced. If there's a birth in the family, if somebody passed away, a lot of times around the holidays, we'll all get together with our family and we'll talk about somebody who passed away. And then that will kind of like naturally progress into us thinking about our own affairs and want us to get everything in order. So, or even if there's an inheritance that you receive. If you've decided that you don't want the guardian listed, the same guardian, you can always change your preferences or naming a different successor trustee or power of attorney. So you can always make those changes. If you choose that you want to name a gift recipient, so a gift recipient would either receive like a tangible item, like I don't know, a boat or a set monetary amount. So say you want to donate $5,000 to the Humane Society, that would be a gift. So you can certainly name gifts that would warrant a change. You can make that update. And then a general passage of time. So it's typically recommended to at least review your documents every 3 to 5 years as life changes. Another change would warrant if you move from one state to another state. While it's not technically like a requirement, it's more of a good thing to consider because state laws, probate state laws, estate planning laws vary from state to state. So I lived in California a few years ago. We still have our California trust. I live in Massachusetts now. I should probably update it to reflect Massachusetts law. So it's just a good rule of thumb. But yeah, so that those are some of the benefits of creating your estate plan. It is budget friendly, easy, convenient, and there is always going to be unlimited support. Hence, Juana being here today, answering these questions. Okay, so some of the benefits of the estate plan solution. So you're always going to have upfront clear pricing. There's never going to be surprises. It is easy to use. It is self-paced. I mentioned the quiz in the very beginning. If you're unsure which plan may be the best for you, you can take that. And then after you select a plan and as you go through answering the additional questions, everything's saved. So estate planning can bring up some pretty deep emotions. And just know that if you need to like take a moment or chat with your potential guardian, everything is saved and you can come back and pick things up. But it is something that you should not put off because we talked about the myth of I can always do it later. Set a goal to have this completed. We're still technically in the new year. We're quickly approaching February, but mark a date on your calendar of when you're wanting to complete this so it doesn't get pushed off and forgotten. And completion means you need to notarize the documents. It doesn't mean just print them out or complete the questionnaire. We'll get to that in a second. And then finally, we do have unlimited support. So both in English and Spanish. So if you are more comfortable speaking in Spanish, we can definitely help you out. Okay, so the different products that are offered and the pricing, there's three different plans here. The first is the power of attorney. I mentioned this is great for young adults going off to college for the first time, want to name mom and dad as their financial power of attorney and their healthcare directive, or maybe somebody else. Um, or if you have an upcoming surgery, great to just have these documents in place just to get something done. Then there's the will package. There's a single pricing or joint for married couples. And then finally, there is the trust package, also single pricing and joint pricing. All three of these plans do come with installment options, payment options. So there's a 4 interest-free payment option that you can definitely take advantage of, and they all include unlimited support as well. Speaking of support, so there's two different ways to get a hold of us. If you haven't moved forward with a plan yet and you're still trying to decide or have some questions, schedule time to speak with our estate plan specialist. I'll have a QR code up here shortly, which you can scan and schedule with the team. if there's still questions after this presentation. If you have decided on a plan and you're going through the process, you can contact our support team. There is a direct line right there. There will also be you can get this direct line in the estate planning app or portal as well. It'll pop up in the top left-hand corner, but you're welcome to write that one down. Okay, how the process works. Um, so you'll log into your credit union portal. Um, and you'll click on the estate planning side, and from there you'll complete the quiz. Again, it does take 2 to 3 minutes. You will complete, after you select the plan, you'll complete your purchase and then walk through the questionnaire, which again typically takes about 20 to 40 minutes, give or take. If At the end of that, you'll submit your questionnaire for review. Our team will review everything and then send it over to you when your documents are ready. You'll get an email. And then once your documents are ready, you'll download them and print them and then follow the signing instructions on the first page. So you will need to notarize and sign. Um, you can contact your branch to see if they can notarize for you. If not, just seek notary outside of it. And then once your documents are notarized and they are legally binding, so keep them in a safe place and let loved ones know where they are at.